All right. Here the Court of Appeals of the State of Michigan is now in session. The Honorable Stephen L. Borello, the Honorable Christopher Wilcox, presiding, the Honorable Adrian and all persons that have business herein draw near to the attention and they shall be heard. God save the United States, the State of Michigan, and this honorable.
Hi, everyone. Welcome to day 2 of panel 2 at the Michigan Court of Appeals. As you just heard, my name is Adrian Young. I'm the presiding judge today, and I'm joined by my colleague, Judge Stephen Borello, and my other colleague, Judge Chris Trebilcock. I know I recognize most of you from my years in practice, but I think everyone's familiar with how things work here, but it's worth reminding you, there are some cases that involve children, that involve victims of sexual abuse. Just be mindful that everything's streamed onto YouTube from here. And so we'd really appreciate you exercising confidentiality where appropriate, and even just out of an abundance of caution. So with that, I'll dive in. I'm going to introduce the cases and call the docket numbers. If I mispronounce someone's name, please do correct me, because I want to get that right for you and for your clients. So we'll go ahead and begin with case number 17. It's docket number 376639, People versus Leandre Lamar Childs.
Good morning, Your Honors. Tim Boffman, representing the people of the state of Michigan, and Kim Worthy, the Wayne County prosecutor. My friend from the other side is not endorsed, and I noticed you have a rather full call for the day, so I'm prepared to rest on my brief if the court has no particular questions with regard to the brief.
Any questions? Do you have any questions?
No questions.
Okay.
Nice
Thank
to
you.
see you all.
Nice
Thank
to see you too.
Thank you.
That case will be submitted. Now calling case number 18, docket number 377440, People of Michigan versus Michael DeGraffenried. And we also have Attorney Howell was granted 10 minutes of oral argument as well.
Good morning. May it
Morning.
please the court, Deborah Blair on behalf of the people, the Wayne County Prosecutor's Office, the appellate in this matter. This case really boils down to 3 issues that were raised by the defendant in his successive motion for relief from judgment. The first was a Brady claim regarding Tia Manning's police statements. And I think fundamentally the defendant in the trial court chooses to forget that defendant was present during the preliminary exam when Tia Manning in open court, her police statements were read on the record. So
Let me ask you this, if I can just dive in. I think
Yes.
it's pretty clear from the record that there's some factual errors and that there's some legal errors. And I'm sure you and Mr. Boffman have talked, but the case before this one was the same judge, I believe.
Oh,
So I'm curious what you think we can do as a bench to make sure that these 6,500s get handled with greater fidelity to the court rules. And to make sure that it appeared from the record that, for example, the trial transcripts either weren't made available to the trial court or were not reviewed by the trial court. So I guess that's my first question. Was it the former or the latter? Were the trial transcripts available? And then the second question is, what can we do as an appellate panel to kind of make sure these are being done right the first time?
well, I can't speak specifically as to whether Judge Green read the trial transcript. They certainly were available. I had them, defense counsel had them. If they were requested, I certainly would have printed out a copy. I was able to receive them from the Odyssey website. So I don't think that the accessibility was necessarily the problem here, but certainly
There's a pattern. I think
Mhm.
what we're getting at here is there's a pattern. is there any evidence of vindictiveness or anything that you wants to bring to this court's attention that we need to be aware of? Because this is frankly silly nonsense that's wasting a lot of people's time.
Well, I certainly, as a prosecutor, felt like I was behind the eight ball the whole time this case was going on. Like, as if the burden was again on the people, like the defendant hadn't had a trial, a direct appeal, a motion for relief from judgment where he raised 12 issues, and now we're at successive motion for relief from judgment. I still felt like the judge was putting the onus on the prosecutor to essentially reprove the case. And I just think that in her courtroom, it seems to be that is the pattern, in my opinion. And certainly this case is an example of that.
And I didn't mean to cut you off. I just wanted to say that we've read the briefs and we've identified several legal and factual errors, but I know you were in the middle of discussing some.
Yeah, if you want to jump in on that.
So she set you up so perfectly.
Yeah, I feel like,
You're gonna win, so what more can you say,
right,
right?
I just,
We're sort of at a loss as to what more we can do. Because we recognize that this is unacceptable and difficult for a lot of people.
Well, yeah, I mean, not only us, not only you, not only defense counsel, but it creates a false sense of optimism in these defendants who think they're going to get another shot at the apple when clearly, the law does not provide that type of relief. So it doesn't do anybody in the criminal justice system any good. And when we see, quote, repeat offenders, end quote, like this particular judge, we want to know, is there something that we can do to say, hey, either learn the law candidly, pay more attention, or is this vindictiveness on your part against the people?
yeah, and I think that definitely needs exploring.
I mean, we know, we are well aware of the background here. We're aware that there was a proceeding involving this particular judge, that she was found guilty of covering up or attempting to cover up a crime committed by her son. And if there was some reverberation from that, it would not surprise me, but I don't know if that's the case. But it certainly is starting to look to be that way.
And that,
Like you're going to pay for this.
yeah, and that's how I felt during this case, because the target kept moving, that I was never, as a prosecutor, secured that these were the only issues that were going to be raised. As the case was adjourned multiple times, more and more issues were then added, changed, removed. It was a very difficult case for beginning to end, but unless the panel has any other questions, I would
Thank you. We
rest on my brief.
appreciate you bringing this to our attention.
Thank you. Thank you. This case will be, or unless you want to rebut, nothing. Okay. This case will be submitted. Now calling case number 19-370914, People versus Delano Marquez. Sorry, go ahead.
Good morning, Mitch Tips for the people. Mr. McKasick emailed me this morning and called the clerk's office that he was not feeling well. He was preserved, but since I do not have an opponent, I will rest on my brief and answer any questions that the court has.
Don't have any questions.
You? I don't. Thank you so much. And thanks for updating me. I did not get that notice, but I appreciate you
Yeah,
both for letting us
Good he
know.
let you know.
Yeah. Thank you.
Thank you.
We appreciate it. That case will be submitted. Now calling, case number 20. This is People of Michigan versus Ryan McLeod. Anyone checked in?
The one case we.
I was gonna say that, I know people can't help being sick, but there are cases where we could really use the help of people coming in, especially when we're counting on them to be here for oral advocacy. And this just happens to be one of them that the panel had a lot of questions on. So it's unfortunate that we're going to submit this just on the briefs. And hopefully that gets remedied in the future where we can have representation here when they're endorsed. So that case will be submitted. Case number 21, docket number 371886, People of Michigan versus Devontae Burkett.
Morning, Your Honors.
Morning.
Ronald Ambrose appearing on behalf of Mr. Burkett. This is a felony firearm possession case. Mr. Burkett was charged with these offenses. He was at a location that was not his residence. He was found in a bedroom that was not his bedroom. The officers came in with an arrest warrant, but no search warrant for the whole residence. Mr. Burkett is arrested, handcuffed, taken away from the location, from the area, and an officer who has certainly some credibility problems finds a firearm. We've raised a number of issues in this case.
Weren't there a number of other officers, setting aside the issues with Janzarek, I believe, Deputy Janzarek, if I say that correctly?
Yeah.
Weren't there a number of other officers in that same room at the time when the gun was located, and it was located right where, right behind your client who was standing next to the bed?
I know there was at least one other officer that was there.
Okay, so there was at least one other officer, even if you threw out his testimony, you'd still have another officer available to testify where a defendant was located in relationship to where the gun was found.
Yeah, and my response to that is you have to, I believe as a trial attorney in such a situation, you have to raise the credibility issue there. And certainly Deputy Janzarek had some credibility issues. And then you go into another area of, well, was Deputy Janzarek, after admitting to multiple occasions of perjury, was he ever sanctioned by, he kept his job.
Isn't there, given the other witnesses, isn't that a matter of trial strategy, whether or not you want to go after the officer and attack on his credibility when there were other ways to challenge whether or not that gun was actually the defendant's?
I think it just gives a jury an idea, plants the seed in their head. Well, maybe this officer isn't being truthful again, and maybe he kept his job, and maybe there's an officer that's protecting.
Would you do that in every case?
I don't see the downside. I really don't see the
Yeah,
downside.
I can't imagine being a criminal defense attorney and having an officer like this guy. And this wasn't something that trial counsel had to peel back. It was well known. In fact, the state admits that they have dismissed numerous cases upon which this officer's testimony was based. So I don't understand how is it strategy to just not ask? Isn't it true? It just doesn't make a lick of sense to me, because he's in the chain of custody. And that's the only evidence, to be candid. That's the only evidence really that they have against your client is the fingerprints on the gun, or the DNA on the gun. And he's the guy who allegedly found the gun.
And there's a multiple DNA on that gun.
Right, right.
And so, yeah, I agree with you.
Well, I didn't think you'd argue, but.
And, in my questioning and we had an evidentiary hearing, and my questioning at the evidentiary hearing was limited. Because all I wanted to know was, did he know? Because the judge kind of gave me a little pushback on how I raised it, because I didn't know that he knew that this officer had committed perjury in the past. So, so I raised it as more or less a Brady issue, but it turns out the prosecution was forthright in providing this information to the attorney. And my questioning at the evidentiary hearing was, did you know about it? And he said, yeah, I knew about it. And it was like, okay, well, we held this evidentiary hearing more or less to find out why he didn't, because the judge was specific as to, the limits of the evidentiary hearing. And so he knew about it and didn't raise it.
So in terms of relief, do you seek a broader evidentiary hearing?
Well, yeah, there are a number of ineffective assistance of counsel issues here, and I do want to state, we do have, Mr. Burkett's has another case, and we are set for an evidentiary hearing in a week and a half on a competency issue. And that competency issue is, in my opinion, it's of major significance, because this trial here happens, I think it ends in mid-June of 2024, and his other case ends about a month later.
This would be the case that's
2 months later.
that's referenced here too, where he was initially adjudicated incompetent, and would I be correct?
Yes.
Okay.
And there's no independent evaluation of Mr. Burkett, and certainly at the time of trial, I found the transcript enough that would suggest, well, maybe we should get an independent. So yeah, I would like a more broad evidentiary hearing.
Was there, and I know that you raised competency here as well as part of your ineffective assistance, was there an expert retained in this case to adjudicate or to give an opinion as to competency?
Not that I'm aware of at all.
Okay.
My review was that there was never an independent done. I can rest on the remainder of my brief.
And you have time for rebuttal.
Okay, very good.
Yeah, thank you so much.
Thank you.
Good morning, Your Honors. Jeffrey Keelan, appearing on behalf of the people of the state of Michigan. Before I start, I would like to introduce a new, mostly appellate attorney. He's going to be in the appeals division. He's already started. Shane Polo is in the back. Shane, stand up. He's already briefed a few issues, so you will see him more and more, and I wanted to at least introduce him to this.
Well, now we not need to know who he's replacing. Who'd you fire?
No, Danielle, Danielle left, and this is replacing Danielle.
Oh, she
Yes.
did. I
Yeah,
didn't, I
she-
was unaware of that. Miss
Apparently-
Walton is gone, huh?
She is apparently being the chief of Genesee, which is close to where she lives, more money and a better office is more appealing than staying. with
Why
her
would she,
friends.
why would she ever leave?
Yeah, I'm not saying I'm not hurt, but yeah, so she left, and we do have some personnel.
And Marilyn
issues.
Day is fake
Sort of.
retired?
Yes, full retired,
Yeah.
exactly. She does part-time
So is Tim
work.
Boffman,
Yes,
so,
right,
yeah.
right.
Yes,
That's,
yeah.
so we're glad that she's still here, but I feel like when she really appreciates your freedom, it's not going to be long lasting, but I hope it is. 'Cause
Well, congratulations, Mr. Colo, and welcome.
he was a staff attorney for a trial court before, and he has trial experience. So hopefully that'll bring a better mix. With regard to our case, I'll address the Deputy Janzarek issue. Deputy Janzarek was a Pontiac police officer that became a deputy. There was a trial court case where the search warrant was lost, and he was the one during trial that brought up, he's like, well, there was a search warrant for GPS. No one had it. This trial, there was a hearing where an APA who's no longer with our office testified. He never gave it to me, and he said, no, I gave a copy. The judge had to decide who was truthful, and they said, okay, I'm going to believe the APA. That was the first case. There was a
So
second.
before you get
Yes.
too into the weeds about the circumstances under which he lied or didn't.
Yeah.
First, good on you for providing it, but also how is it not ineffective for using it? You're saying that the nuances of the hearings for which
Yes,
he was disbelieved by a court
yes.
aren't sufficient to at least impeach him at.
I'm saying that, yes, so that was a first, and then the second one, the trial court who heard his testimony believed he was truthful, and the Court of Appeals, based part on that previous case, said no. My point is that the trial counsel, Richard Taylor, is a seasoned veteran of 50th. He's known Deputy Janzarek since he began. He's questioned him. Deputy Janzarek is very articulate. The elected prosecutor did dismiss cases initially when there wasn't an independent witness like this case where there was another officer that was in the room initially. They took the pictures and multiple officers around as well. So when there was a case entirely relying on his testimony initially, those were the cases that were dismissed based on an elected prosecutor's decision. Since that time, he has testified in a number of cases. It has been brought up on different cases, and the jury inevitably states something to the effect of, if that's the best they have. It isn't, when he's able to explain what really happened and his perceptions of it, we have yet to have a jury be concerned at all with what he's telling is true, especially in a scenario like this, where, again, he entered the room with another person, the defendant was right there, and the officer saw the gun as it was lifted up. There was a photograph of it, there was DNA on it. All of that evidence in total would have been a distraction from Mr. Taylor's arguments in this case and wouldn't have been fruitful.
What were Mr. Taylor's arguments?
I would have to look at that. I think,
Yeah.
That's yeah, I don't know that.
You don't dispute that this is the best piece of evidence that the people had against.
oh, the gun was
this
entirely
defendant.
damaged. Yeah, what the gun, but I
With
mean,
the
to
DNA.
believe that he would have had to have somehow manufactured it would be what? He brought a gun with him. I mean, the scenarios in which the fact that he was found to be not credible earlier would relate to a case where two officers entered a room, defendant was arrested right next to it. They both testified, yeah, there was a gun there. We took pictures of it. It has DNA. Defendant acknowledges in his brief the defendant was removed from the room before they got to the gun and removed it. So somehow they would have had to have also planted the DNA on there. Because again, it's
My reading of what Taylor did based on the Ginther hearing is that he wanted to highlight, look, there was other people's DNA on the gun. There were multiple people in the house.
Right.
It wasn't, that was what he focused on, is like, look, you can't prove beyond a reasonable doubt that was his.
that refreshes my recollection. Yes. And even if he did touch it at one point, there's no proof that he knew it was in. There was an acknowledgement again, that wasn't his bedroom. We were never disputing that. It was someone else's bedroom. In fact, the officer even brought in testimony from that person who wasn't there conceding, yes, it wasn't his bedroom. But at the end of the day, there's evidence that officers entered. You could hear them entering. He was in the back bedroom, plenty of time to take a firearm and hide it somewhere because he did have a warrant and he was on parole. But he'd hide it somewhere that's not visible, but it's clearly very easily accessible to him if he needs to get to it, which is the perfect place under the bed. So the credibility issue with Deputy Janzarek, again, there's no scenario that I would foresee, and Mr. Taylor acknowledged that he knew of it, and he saw no benefit to raise that because that would just be a distraction from the case. And again, honestly, Deputy
Well, the
Janzarek.
answer is yes. It, I
I-
mean, you talk like a jazz musician blows in the horn. You never taken a breath, so I have to interrupt you. I
No,
apologize, but so the answer to my question though initially was this was the best piece of evidence that you had, and that would be a yes. So then the next question would be, if I have evidence as trial counsel, if I have evidence that would put into question the chain of evidence or put into question the credibility of somebody involved in the chain of evidence, and I'm well aware of that, why would I not just one question? And your response is because it would be too, it would be too what?
Because juries have not received it in other cases, because he's a very likable, very articulate person. A jury could think, well, what the phrases I've heard were, if that's the best they have, of course he's guilty. That happened in one of the cases. I don't think it was.
Now, see, to me as an old trial lawyer, that makes me want to ask it even more, because if he's that good of a witness, I'm going to want to knock him down, right?
he's good because, in my opinion, because it's someone that I've worked with for a number of years, not recently, but when I was in the trial world, he's reasonable. My impression, other than this, he's very honest. He's one of those people that will concede all of the negatives. Say, no, absolutely this, and this. And so the question is that going to benefit it? Again, when two officers are in there, they both see the same thing. It's within his reach. There's DNA. Is that going to make a difference when he's focusing on, well, maybe he touched it at one point, but he didn't know it was there. It was someone else's bedroom. You can't prove that he knew if it was at that location at that moment because he didn't say he knew about it. So
What's the downside of pursuing this line of questioning, in your opinion?
alienating the jury if they like a witness and you appear to be attacking them. That's quintessential trial strategy. If they like a witness and you're attacking that witness, you have a potential to alienate the jury. And in this case, Deputy Janzarek now is a very likable, very reasonable. Again, one of those people that concedes everything. He doesn't hide. He's like, oh yes, this bad happened. This sometimes more than we would have liked, but it's all true. And so when you attack a witness like that, you have a risk of alienating the jury. Mr. Taylor himself, he comes across, I realize on the transcript, not as effective.
Yes, that is
He's one of
correct.
those amazingly likable people that you just meet and you go, gosh, I want to agree with that man.
I
There's a
think
few
you
out
like people who you can roll over.
if you ever watch the video of it, you'll realize there's a few out there that are just like, wow, like, and a lot of them are retired now because I'm old, but yeah, he's a very likable person that's basically a skill set is juries don't want to convict oftentimes when he's arguing, when he's advocating, it's like, he's like a neighbor. But that's the risk is when you have a likable witness.
Appreciate that.
And
Thank you.
again, the downside is that the upside is someone else saw it. There's DNA, there's no scenario in which a lie would allow this evidence to be found in the way and manner. it was.
So in essence, what you're arguing is, look, Your Honor, even if you find he was ineffective, which candidly he is, for failing to raise this, the second prong is you have to demonstrate that there was prejudice and you can't meet that.
Yeah, that would be the conclusion. I would still see in light of everything, that to me, that's trial strategy is if I'm not going to attack a witness if I don't think it's going to be a gain and I worry the jury is going to hold it against me, like kids, children, witnesses, women. So there's certain people that are very sympathetic that you don't want to go after harshly because they're going to not like you for it. But yes, that certainly there would be no prejudice regardless in light of all the evidence. The only other thing I would note, and I talked with counsel about this, was the Hughes case is a published case on the felon in possession Bruin issue that is obviously,
Right.
it came out in the middle of all of our proceedings. So that obviously plays into it. I feel like it fits within our arguments. Other than that, I would reserve unless the court has any questions, I have nothing further. to
Thank you.
add.
Appreciate your candor as always.
I'm not arguing that he should have focused on that particular.
Just should have asked, right?
Yeah, and depending on the answer, as a trial attorney, sometimes you don't attack, but if he gets adversarial with you, then there might be a good give and take.
I've never known a criminal defense attorney who had a police officer who had credibility issues not to go after that officer.
And if you want to talk about prejudice, it's not found on Mr., this gun's not found on Mr. Burkett, so I've seen.
All you got to do is put reasonable doubt in the minds of the jury, right?
Exactly.
And why wasn't the fact that the challenging of multiple other people's DNA evidence and the fact that it wasn't his house, it wasn't his room, there was another person in the room, all of that come down to trial strategy, whether or not then you've got all that, does the risk of attacking the credibility of this officer outweigh the benefit when you've got all this other evidence to provide reasonable doubt?
No, I think it's just one more thing that can be asked.
It's just a plus, no negative.
There's, and you don't have to attack. That's probably, depending on how he answers, it's probably the worst thing that you can have if, brother counsel's statement of how he interacts with juries is correct, but you want it out there, certainly. Maybe he's a good liar.
Any other questions?
No, thank you
Questions?
both.
Thank you both very much.
Interesting case.
This case will be submitted. Now calling case number 22, docket number 374903. This is Citizens United Reciprocal Exchange versus CNMC Incorporated.
Good morning.
Morning.
My name is Jordan Weiner. I represent Cure. I'd like to reserve some time for rebuttal, and I hope it's a substantial amount.
Okay,
Um,
I'm gonna have you keep track of your time, but if you get close to running over, then I'll yell at you.
If I get close to running over, I'm going to yell at myself.
Okay.
I think I made this issue a little more complicated than I think I needed it to be because
That's putting it mild.
I think that what it really boils down to is it doesn't matter what the reasonableness of the towing rates are, because even if they're reasonable, there's still a tortious conspiracy here and there's subject matter jurisdiction. Right. So we look at the complaint. The complaint establishes subject matter jurisdiction in the circuit court. The defendant.
Typically, here's the issue though, and I have to tell you, I don't know what I'm gonna do. Usually I know how I'm gonna roll, as you could tell from the last one. But on this one, I'm up in the air. I would agree with you. Typically, this would be circuit court, but there seems to be a statutory preclusion here. That, and what the only issue that I have is, does that statute, if you will, sort of swallow up all of these other claims?
So I don't think it does. And that's where that Ronaldo's construction case kind of comes in, where you look at that statute that gave the Public Service Commission a broad amount of authority, a broad amount of power, and it lists it all matters. And this court said, no, that excludes tortious conduct, right? And that's what we have here. We have a conspiracy to engage in tortious conduct, and a lot of the conduct is outside of the motor vehicle code.
But doesn't the conduct arise from, you don't have that conduct, or you don't have those claims, but for a towing company towing a car and storing it pursuant to the statute. Is that right? If you don't have a towing under the statute, you admit that you would agree that towing a car from an accident scene, right, and storing it falls under the statute, right?
Yes.
And they can charge storing fees and towing fees, correct?
Yeah. Yeah.
So how does any claim that arises out of those operative facts not fall underneath that statutory jurisdictional grant?
Because the tortious conduct really doesn't begin with the towing of the car. It begins with once the car leaves the towing agency and goes to Grand Sport in this instance, right? So there's evidence of a conspiracy between the repair facility, Grand Sport, and at least, this particular towing agency and all the other towing agencies that are defendants that chose not to participate in the action. And so the towing company gets the car and it's properly within the towing company's possession, right? But then we even look to the contract that Area Towing had with the police department. It improperly delegated the place of safekeeping to Grand Sport, right? So it said, all right, Grand Sport, we're going to send the car to you at your request, not at the request of the insured or the owner of the car.
But doesn't it all fall? I just have a real hard time coming out of the operative fact that all that process starts with the towing, processing, and storing, which falls under the statute.
But the tortious act happened with Grand Sport, who's outside of the regulatory scheme. So if this was an action where, my car gets towed and I want to get it back, and I'm angry because I have to pay $1,080 to get it back before I can even gain entry to the courthouse, I would agree with you. That's something where it would likely fall within the statute. This is well beyond that. This is a well-orchestrated scheme to come up with fees that are not regulated by the act, by participants who are not regulated in the act, and possession of the vehicle that's not regulated by the act. So everything happens after the fact. And the conspiracy is really brought to fruition because the action is taken outside of any agreement or direction of the owner of the vehicle or the insurance company. So the record reflects that in this case, at least with the vehicle that went to area towing, that Grand Sport said to area towing, send me this car and we'll pay you everything that you charged, no questions asked. And then Grand Sport, which doesn't have the ability to say that I'm the tow agency or I'm a custodian, and then
How does that not fall into the term processing?
because this isn't about process, this is about tortious conduct, about disguising unlawful conduct as lawful. That's a separate actionable tort, and that's what the conspiracy alleges.
So you're saying that the statutory language processing refers to the legal processing. And once you're in illegal processing, you're no longer processing under the statutory language.
Right, so the word processing in the statute deals with just the actual ministerial acts that are enumerated and regulated within the statute. When we get outside of the statute doesn't regulate it, right? So that's basically the long and short of it. And the argument that we've seen from area towing is you're only challenging the reasonableness of our fees. And my answer to that is no, we're not. We're challenging the tortious conspiracy where Grand Sport charges fees for services that it didn't provide, that nobody agreed to, and that aren't regulated by the act.
Doesn't the statute also include language that you can ask the court to hold a hearing for the purpose of determining whether the towing agency or custodian, quote, acted properly? Isn't that included in the statute?
Well, that's narrower than all matters under the Ronaldo case. This is tortious conduct. The statute doesn't govern tortious conduct.
So acting properly doesn't encompass whether or not your conduct was tortious or not.
No, acting properly is whether they followed the ministerial acts that are outlined in the statute. Did they put it in lien properly? Did they notify the Secretary of State? Did they actually take the vehicle from an accident scene at the direction of a police agency or at the direction of a private property owner? Those are the types of things that are processing. Tortious.
And what's your basis for that? What's your legal basis for how you say that that's what it is?
Just the statutory interpretation that goes through in the brief, generally accepted principles of statutory interpretation, giving the word processing its plain and ordinary meaning. It's not defined in the statute. We looked at dictionaries and we come up and we figure out what it means. The brief goes through a very technical statutory analysis of the word processing.
But I guess where I struggle is the statute says car's disabled at an accident, right?
Correct.
I'm a simple guy. Get in an accident, car's disabled, police can call towing agency's called, they take a car to the storage place. And there's fees and costs associated with that, right?
Yes.
And that's all done pursuant to contract and agreements between, which towing companies the police agency use. And there's a lot of issues with that happens, where the storage cases are, all of those things. How does allegations that say how they're doing that processing and towing a car and using that process to either charge unreasonable fees or they've all colluded to refer things, how does that not all arise? Unless the one exception I could see is if, it's a criminal matter.
Well, I mean, this court's already found that tortious conduct is outside of the statute in the nationwide towing case. It's an unpublished case, and that was a conspiracy to fabricate stolen vehicles. And the city of Detroit said, nope, that's a nuisance. So you have to stop fabricating stolen vehicles so you could go tow them and demand these fees. And really all this is doing is it's a conspiracy to fabricate gate fees and pull out fees and all of these other fees in a 35% markup fee. And it's going around the insured and the owner of the vehicle who never actually has an opportunity to go and deal with area towing directly. The car was there for 12 hours. And then a repair facility says, I'll give you $1,040 if you bring it over to my lot here. And then all of a sudden it goes from $1,040 to $6,500 and nobody did anything.
But isn't the difference in nationwide? Nationwide is unclear that whether the city itself could initiate an action And two, in Nationwide, they asked for specific equitable relief, where here, the remedy you want for your claims is money.
Well, it's still, there's an unjust enrichment claim, which is equitable, but the
But it
tortious-
still comes down to money.
right, but there's still tortious acts too, right? Nuisance is a tort, is a tort. So if I just look at it from a more simple perspective, because I like to think I'm a simple guy, even though maybe the briefing doesn't reflect it, but a tort's a tort's a tort. So if tortious conduct was outside the scope of the statute in the Nationwide towing case, then tortious conduct is outside the statute in this case too. You know, if it's a conspiracy to enter to engage in tortious conduct, the ability for the towing company to say, you are stuck with a remedy and you are stuck in the district court, regardless of how egregious the conduct is, it creates limited tort immunity that the delegation of jurisdiction doesn't contemplate. So we can't abrogate the common law by implication. And that's really what their argument kind of boils down to, which is anything that starts from a lawful towing of a vehicle absolutely falls within this delegation of jurisdiction to the district court. And that's just not true. So the tortious conduct it's separately actionable. And the towing company isn't necessarily in for its own tortious conduct. It's in under the conspiracy count. It's a co-conspirator to create an advantage for Grand Sport, which is not regulated by the Act. So if I have a separately actionable claim against Grand Sport, that's where the tortious conduct begins. And if the towing company ends in as a co-conspirator, then they're equally responsible. And that's where the subject matter jurisdiction comes down to.
So does that claim then, is that a different analysis now that you only have one defendant? All the other parties have been dismissed from the case, correct?
Well, the whole case got dismissed.
Yeah, I mean, but all the other defendants, the only vehicle at issue presently in the case is one company, one car, correct?
Yeah, I mean, they're defaulted, right?
Yeah.
So, I mean, I don't think it necessarily changes the nature of anything because we're still able to argue the breadth of the conspiracy. They chose not to participate. Their default doesn't implicate anything against area towing, but it does show the breadth of the conspiracy, right? So I think that everything kind of starts with the really wrongful conduct outside of the statute. And it would be tremendously inequitable to allow a towing agency to escape liability for obviously tortious conduct because it just happened to lawfully tow a vehicle from an accident scene, even if it was
But
under the pretense.
doesn't that go a step too far? It's not that they can avoid it. It's just the court in which it's initially heard. Because the district court still has authority to provide full remedies.
I don't, so that's not really what they argued below. They argued that the exclusive remedy is contained in the motor vehicle code too. They're saying that not only do you go to the district court, but you're stuck with the exclusive remedy provisions too. So we wouldn't be able to get treble
But is
damages.
that issue on appeal? The exclusive remedy provision of that?
It's briefed in the brief, and the response is, well, the trial judge didn't really talk about or make a ruling on the exclusive remedy issue, but we talk about it in our brief as, part of the issue
The
here.
court did or did not make a ruling on the exclusive remedy?
No, the trial court didn't rule on the exclusive
Okay.
remedy issue, but the trail of breadcrumbs on the jurisdiction was, look, everything is in the district court. It's jurisdiction and exclusive remedy in the district court, and we disagreed with all of that.
All right, so let me, first of all, I live in cow country. You cannot wear a bow tie and call yourself a simple guy. It just does not work. So if I look at 252E, just bear with my ignorance here. Oh boy, I just went to the legislature somehow. We're not worried about the word reporting, correct?
Nope.
All right. So it all comes down to processing.
Right.
And what that entails, correct?
Yes.
All right. I just wanted to make absolutely sure.
And so my interpretation is processing excludes tortious conduct. and area towing says processing includes reasonable fees. And my position is that even if their fees are reasonable, let's say they only charged $1, there's still a co-conspirator in the tort. So the claim doesn't rise and fall on the reasonableness of the towing fees. The claims rise and fall on the tortious conduct started by Grand Sport in which area towing co-conspired.
But if they didn't process the vehicle, there would be no tort. Can we agree on that?
If they didn't tow the vehicle,
If they didn't
Right, yeah,
process,
yeah,
if they
but-
didn't tow and process the vehicle, there would be no tort.
right, because there wouldn't have been a vehicle that would have flowed to Grand Sport, but they don't have to go steal the vehicles to engage in a tortious conspiracy either. Like that's kind of, the theme is they can't disguise unlawful conduct as lawful and then force us into the district court.
And say you're bound by the limits of what the district court can and cannot do.
Correct.
So essentially what you're arguing too in the brief and also today is if you compel me to go into the district court, you in essence strip from my clients the right to make several arguments.
Absolutely. Like we're not going to be able to get above the $25,000
Grossly limit
threshold.
my damages.
Yes.
Well, I mean, candidly, a district court can award above, but what you're talking about as a threshold is a circuit court, a matter for equitable purposes as well as the $25,000
Right.
threshold, which your client, I think, believes that they would have no trouble.
Yeah, I mean, I think the complaint starts at $55,000 or something like that in damages, and then we would add on, the statutory treble damages for conversion. So I mean, it's a considerable case, and if it's a concerted action specifically to target, insurance companies like this. So
I understand that policy arguments, at least with the last regime, were not kindly taken to. But are you essentially making a policy argument here as well on behalf of your clients that if you preclude my clients from pursuing this, you're in essence allowing somebody to escape the full breadth of the law by simply hiding under a statute and saying, oh, you can't sue me. You're immunizing them to some degree.
yes, and we there's language like that in the briefing where we talk
Right.
about they can't use this jurisdictional statute to immunize themselves from tort liability.
But, one last question is, does the statute in and of itself grant a court, let's say it's the district court or the circuit court, the statute itself, the motor vehicle code anti-theft provisions, does that afford a court the ability to provide full relief?
So
Because doesn't the statute grant whether you think, say it's a district court or a circuit court, allows them to give whatever relief is necessary to make the person whole who has been damaged by a violation of that statute. Is that correct?
not really, because if you accept area towing's exclusive remedy argument that they made in the trial court, then we're stuck with the procedures in 252A that your relief based on an unreasonable towing fee is the difference between a reasonable towing fee and the unreasonable towing fee, which you have to pay the entire thing in advance too. So
Doesn't the statute also say that the court can give whatever other relief is necessary? Isn't there like a broad catch-all in the statute?
I'm not aware. There might be one, but I don't think I recall seeing one very specifically.
Okay, I could be wrong,
Yeah,
but
I mean,
I thought it was in there.
There's an exclusive remedy provision, and the remedies are really narrow. But even so, like again, this isn't just a question of the reasonableness of their fees. It's the tortious conduct on top of it. Thank you.
Very good argument. Thank you, counsel.
Morning, Artist James Austin, on behalf of Area Towing with my co-counsel Anna Waller. To start with, while we made an exclusive remedies argument at the circuit court level, that wasn't decided on. That would have to go down to district court with everything else to see whether everything that's being charged against area towing, and area towing, just the tower in this. They had a very small part. But the exclusive remedy provision is worded completely different from the exclusive jurisdiction. Exclusive jurisdiction says that the district court has has jurisdiction over the towing agency to see if they have acted properly in processing the vehicle under 252A, 252B, 252D.
Do you and brother counsel disagree as to the meaning of processing within the statute?
It's a great question because I deal with, this is towing and it's all I do. And processing isn't, removal isn't, towing isn't, none of these things are defined for us. So we're arguing all of that. But processing to me as the towing attorney is step A, police give my client a call and say, we've got an accident, come out here. And from the time that they are called to the scene to the time that that vehicle is either redeemed,
Thank you.
is redeemed or auctioned or scrapped. That's the entire process. And that includes the pricing of that vehicle. So I think it's the entire process, system, scheme that we have there.
So it's all encompassing.
It's all encompassing. And that's, it's statutory, it's non-consensual, and it's the process that the towers have to rely on.
But that's not necessarily different than brother counsel. It's just, he says, once part of that broad processing is tortious, you bump out.
And that's where I disagree, because that is, again, if we're reading the statute, it says whether the towing company agency has acted properly in processing the vehicle. The tortious action would be an improper process, or it would be improperly processing it. That would fall under it just as well. It goes down to the district court, and that's all that Judge Snow ruled on, was that I don't have the ability to decide whether the remedy is proper that you're seeking, whether anything went on wrong here, because this was a vehicle towed under 257-252D. And because of that, it goes down to district court. And because it's such a specific grant of jurisdiction, our position is that allows the district court to expand what it has the ability otherwise under the revised Judiciary Act to take care of. You talked about the $25,000 cap on district courts. This statute takes that away, because I have a $500,000 case in front of a magistrate in district court in Monroe, because it falls under this statute.
And you're referencing in MCL 600.8315, the statute says you're limited to 25,000 except as provided by law.
Right.
And the law in this case is the motor vehicle code anti-theft provisions.
Right.
Which then allows you to go beyond that and provide whatever relief is necessary to effectuate the
Exactly.
purposes.
And Driver v. Hanley says if you have a more specific jurisdictional statute, it takes precedence over the more broad revised judiciary, if I could say it right, statute. The other thing I wanted to bring up was the distinction of the nationwide case. And I think you said a little bit about that. In the nationwide case, the vehicles at issue were towed before they were reported stolen. So none of those vehicles were towed under 257-252D. It never started with this statute. So this statute didn't come in. I know it was argued in that, but the stolen vehicles were somehow Nationwide got a hold of the information. They towed the vehicles, and then the police found out about it. And the police said, this shouldn't be happening. And that goes.
No, go ahead, finish your thought. And I got a related
And
question.
because of that, that's how the nuisance came in, and it sidestepped the statute because it's not a 257-252 D1 tow.
There was some argument about the difference between an abandoned car, a stolen car, or a car towed from an accident. Does jurisdiction change depending on the nature of the tow?
No, because the jurisdiction statute doesn't address abandon at all. And that's one of the problems we get to down in the exclusive remedy, is it says disposition of abandoned vehicles. And I think if we get there, we're going to have a good fight about that. But instead, the jurisdiction says a vehicle that was, whether they properly acted in reporting or processing the vehicle under, in this case, 252D. And that's a very specific set. So that's, and that same vehicle can hit every one of those situations that you just talked about. It can start as impounded if it is a stolen vehicle, if it is a vehicle that's involved in a crime. It can be held on a police hold, and during the police hold, the registered owner of the vehicle is liable for storage during that, but it's not deemed abandoned by the state or the police department until time schedules pursuant to 257-252A5 take place. And then the notice of abandoned vehicle, the TR-52, goes out and alerts that's when that becomes abandoned. What we would argue is that this whole process is the disposition of an abandoned vehicle, because ultimately, at some point, if it goes through the whole system, it will be an abandoned vehicle. And again, we have a statute that I've been dealing with for 30 years that's very inartfully done and very difficult to change. And getting these definitions, and that's why I'm glad you're here to help with this. Anything further?
I don't have anything.
No,
Okay,
thank you.
thank
Thank
you.
you. Thanks for having me. We're usually down in the district court.
So the exclusive remedy provision, I don't know if it does or doesn't actually expand the dollar jurisdictional amount of the district court, because it says this is 252E subsection 4. The remedies under sections 252 to 254 are the exclusive remedies for the disposition of abandoned vehicles. And again, I mean, we're getting back into the arguments that were made in the trial court, which was area towing wanted to piggyback on the exclusive remedy provision in addition to the exclusive jurisdiction provision or the jurisdiction provision. And maybe they go hand in hand, maybe they don't. But I don't see an adequate remedy in the district court. It's one of the things that this court found in the Nationwide towing case was that if the city was in district court, it didn't have an adequate remedy.
Well, let me pause you for a second. We agree, and there's no dispute that the trial court did not issue a ruling on what the exclusive remedy provision means or what the result is under the statute.
Right.
Is that correct?
Correct.
Okay. As it turns to jurisdiction, how do you respond to Brother Counsel's citation to, MCL 600.8315? You rightly hammer and say, look, jurisdiction's limited to 25,000. We've got issues above 25,000, but we still have to read and give effect to the remainder of that sentence that says, except as otherwise provided by law. And the otherwise provided by law is the Michigan Vehicle Code anti-theft provisions, as well as the other provision in MCL 600.8315 that says the district court shall have jurisdiction and power to make any order proper to fully effectuate its orders there. So that seems to be, I think that's what I was referring to earlier. That seems to be a pretty broad grant that once a statute gives the district court jurisdiction, the $25,000 cap doesn't really matter anymore. They are empowered to do whatever they need to do to carry out the purposes of the statute that grants them jurisdiction.
I understand your question, Your Honor. I think that what would happen is that if we had to go down to district court on this and we'd say, district court judge, we want $200,000, they're going to say, but you're capped at 25. And the arguments that I would make, that I'm saying here is, we have a statute that says, except otherwise provided by law. So then the except otherwise provided by law would have to be somewhere in the motor vehicle code that says the damages could exceed $25,000. And I don't see that in 252E subsection 4.
Is there a limit in 252E?
It just says the remedies in 252 to 254 are the exclusive remedies for abandoned vehicles.
Okay, but
And
there's no dollar cap in the statute, right?
No.
Okay, so why would that then place a cap?
Well, so now we're getting into like which one's more specific, which statute's more specific, which one's more general, which one do we apply in terms of district court jurisdiction, right? So I would think that if there was a remedy, one, we'd have to look at everything between 252 and 254 and see what's the remedy. And for the most part, the remedy is the difference between the reasonable fee and an unreasonable fee. It doesn't include the tort remedies. It doesn't include the statutory conversion damages. So I don't think that there is anything in the motor vehicle code that would exceed $25,000 in the district court for a claim that's brought in the district court. And I appreciate counsel's anecdotal comment that he's got a $500,000 case there, but I can only look at what's on in the statute.
But doesn't the statute, the statute says they have jurisdiction and power to make any order proper to fully effectuate the district court's jurisdiction.
Right, which is up to
So-
$25,000 in claims that are not historically equitable unless those claims are actually granted to the district court. And it has to be specific. We can't imply jurisdiction. Like I can't agree with counsel and say this court has jurisdiction to hear all the cases that I happen to bring on Tuesdays, right? Like jurisdiction is set by the Constitution and the statutes. It's not
And
agreeable to.
district courts are not constitutional courts, they're statutory.
Right. They're a court of limited jurisdiction. We can't just imply that there is jurisdiction above what its cap is. And, I generally work in PIP cases, and we see this all the time with amount and controversy issues where, a provider will file a case in district court and have $75,000 in bills, but they're capped at $25,000, right? So like, these are some issues that are really familiar to me on the amount and controversy. One last point, Brother Counsel made an interesting comment on the nationwide towing case where he said those weren't 252D tows. And that's why the tort claim could lie. And my response to that is Grand Sport's possession of the vehicle was not, it's basically the same thing. It's not governed by the statute. So the entire tortious conspiracy, all of the tortious acts are wrapped up in that conduct. And that's why area towing is tied in, not about the amount of money that they charged for their tow or the reasonableness of them taking it from a scene. It's they were wrapped up in a tortious conspiracy by somebody who was outside the statute, just like the stolen cars were in the other case. So
I'm not limited by the exclusive remedy because I'm not dealing with processing as that is normally understood
Right.
within the statute.
Yeah, and if we say, okay, all you have to do, repair facility is get lawfully towed vehicles. Here's your blueprint for insurance fraud. No further questions.
Interesting case. It was very well briefed by
Thank you.
both parties.
Thank you both.
Thank you.
This case will be submitted. Now calling, this is two items that are consolidated. I'm certain they aren't. I'm positive. Yesterday I was just willy-nilly consolidating cases that weren't consolidated. So case number 23, there's two docket numbers associated with it. 374424 and 375030. This is in re attorney fees of Andrew Christopher Sullivan. We have one party endorsed for oral argument, and it's Mr. Sullivan.
Good morning. May it please this honorable court. I am Andrew Sullivan, I think that the case caption speaks for itself as to why I'm here. And in the interest of time, I would rest on my brief and be happy to answer any questions.
Interesting way to start your legal career. Good luck. I don't have any questions for him.
I don't have any.
Thank you.
Thank you.
Thank you.
Brief outline the issues very well. Thank you.
Yes.
The case will be submitted. And we're going to take a brief recess before we begin the 11 o'clock docket. Thank you all.
All right.
Item number 20. Oh, yep. Okay. Yep. We're back on the record
We're doing a little different this afternoon.
with item 24, docket number 370517. This is Yusuf A. High versus CIG Capital Advisors. And let me just pause for a second. You can come up to the podium. If I mispronounce someone's name, please do correct me. I know I mentioned that earlier, but it's worth saying again.
Good morning, and may it please the court. My name is Jim Garvey, and I represent the appellant CIG Capital Advisors. I'll refer to my client as CIG. I'd like to reserve a few minutes for rebuttal.
All of you keep track of your own time, but I don't think that'll be difficult.
Understood.
I have some time for rebuttal.
Thank you.
Mhm.
So what are we asking this court to do? On February 13th, 2024, in the lower court, judgment against CIG was entered on a verdict of the jury in the amount of $3 million. After post-trial motions, which were denied by the trial court, this timely appeal followed. There is no cross appeal by the appellee. We have raised 7 separate and distinct issues for this court's consideration, any one of which we submit warrants vacation of the judgment entered by the trial court. And we therefore are asking this court to remand the case to the trial court with instructions for entry of judgment in favor of CIG. This appeal arises from a jury verdict that cannot stand because it is the product of multiple compounding legal errors that distorted the case presented to the jury. At its core, this case involved a straightforward question: whether the plaintiff was entitled to an equity interest under a written employment agreement in an operating division of CIG. By the time the case reached the jury, that issue had been transformed into something entirely different.
Let me just jump to one of the issues you raised on appeal was that somehow providing monetary damages for the value of the equity somehow put plaintiff in a better position. I struggle understanding that. Either way, there was a remedy provided, whether it was the value of the company, the equity stake in the company, or monetary damages. There was a breach, and for most contract breaches, the remedy is money. So in this case, why does this equity stake require specific performance? Unless I missed it, they didn't request a specific performance remedy in the lawsuit. Maybe they did, but why was that outside the reasonable outcomes?
It was because of the plain language of the 2007 letter agreement that is at issue in this case. And I would refer your honor to section F of that letter agreement, which is in the appendix, our appendix at page 580. So all that provision does is provide the plaintiff with a contingent, illiquid potential interest in this operating unit. There's nothing in that provision whereby it is contemplated by the parties as to how that interest, even if the jury properly found, which we dispute, as the court knows, even if the jury found, and it was not against the great weight of evidence for the jury to find that the plaintiff had an interest, to put the parties in the position that they would be in pursuant to the contract that they signed would be to give plaintiff that interest. It wouldn't be to monetize it. And the reason additionally is that there's nothing in the contract that indicates how it can be monetized, what the value of the monetization would be.
But isn't that
under
the
what
case? Isn't that the
circumstances.
situation in every case? I have a 25%. I should have, when my employment ended, I should have had a vested 25% stake in the company. The company's valuation, however you come up with that, and there's business, you can have a dispute about the proper procedure for that, whether it's a third party, each party puts it in, however you do that, right? But there is a value that is come up with that. Why is it that if there is a breach, that the person isn't awarded that monetary value at the point of that breach?
Because the proper remedy is specific performance, given that there's nothing about the breach that can be tied directly to any particular damage or loss. There isn't.
Isn't the damage or loss 25% of the value of the company on the date of the loss?
Absolutely not. There is no damage or loss because there has been no monetization of anyone's interest in the company. Plaintiff himself even testified at trial that the benefit to having equity in any asset is when that asset is sold. And so the 51% owner of CIG wouldn't be entitled to a forced buyout of his equity interest, but that's the result that obtained here. And there's two additional points on this excellent question, of course.
So what
Your
if,
Honor.
let me ask it a
Yeah.
different way then. What would happen then if the court at the time you awarded a 25% interest was January 1 or today, right? But
Yeah.
when you breached the contract a year ago, the company was worth 20% more. When the breach happened, the company was worth 20% more. But now when you award it, it's worth 20% less. How do you account for that then? Why am I going to get a 20% stake? When you breached my stake, it was worth $1 million. And now when you're giving it to me, that 20% is only worth $500,000.
Well, I think the disconnect between us, Your Honor, is that the breach, what is the breach? The breach here was an alleged failure to recognize the equity interest in this business unit with the acronym BAS, right? That's the alleged breach, and the jury found that breach, right? We know from the short form verdict form that the trial court used. So the jury didn't say when the breach occurred, and there's nothing. So if the breach is the failure to recognize the interest, then the remedy is that interest be recognized, not that it be monetized. And the two things I would ask the court to consider in that respect is first the operative pleading, right? The second amended complaint. In his opposition brief on appeal, plaintiff argues that in the second amended complaint at certain allegations, I think it's numbers 45, 46, 47, and 79, there was a request for damages related to this unrecognized equity stake. And that's simply not the case. In the paragraphs that are numbered in the 40s in the second amended complaint, that relates to plaintiff's fraud and silent fraud claim, which the defendants, and there were many more defendants in the lower court, that claim had already been disposed of in the defendant's favor. The only allegation in the second amended complaint in the breach of contract claim that relates to this equity interest is paragraph 77, where it is pleaded that the April 25, 2007 agreement, by the way, this is appendix page 45, the appellant's appendix. The April 25, 2027 agreement and subsequent amendments entitle plaintiff to an equity interest in CIG as a purveyor of business and advisory consulting services. That's what this case was litigated about for 2 years, separate and distinct from the other claims that were decided in defendant's favor and which are not the subject of this appeal. And you know this as well, Your Honor, that not even the plaintiff himself contemplated until just before trial an arguable or potential monetization of this interest if the jury recognized there to be one, because in the damages report that his retained damages expert issued in February of 2023, so roughly 8 or 9 months before the trial, she explicitly said in the report that she was not offering any valuation of the business interest or any valuation of this particular business unit. And so not even the plaintiff was contemplating during the expert phase of this case, proffering an expert to testify to what the value of this interest may be. What happened was in November of 2023, just before the trial started, plaintiff made another proffer of that same expert, Susan Koss, and proffered her for the purpose of offering a valuation of the business unit. This was a last minute decision or approach by the plaintiff or attempt by the plaintiff to seek relief that had not been sought in the operative pleading, was not the subject of fact or expert discovery. And as the trial court correctly characterized it in barring Ms. Koss from providing a valuation of the business unit, this is the epitome of trial by ambush. That was the trial court's ruling in excluding any expert testimony on what this valuation or potential valuation, if one is even possible, could be. And that decision by the trial court has not been appealed. That's the case that we went to trial.
Why are we talking about it?
We're talking about it because to Justice Trevelcock's question about isn't monetization the proper relief, the answer is no, because one, specific performance relief gives the relief that the parties contemplated in their own contract. And number two, this case was not litigated.
In that contract, does it say any breach of this is limited to specific performance?
No, it does not.
Okay.
It does
So
not.
then how is it that's what was contemplated by the parties?
Well, because it says that an equity, I'm reading from section F, Your Honor, an equity interest to be vested on your third anniversary with CIG based on consulting revenue hurdle rates to be established on an annual basis. And then it goes on to say in the event that CIG is sold, any granted equity will be automatically vested. So we don't even have, given that there wasn't a sale of CIG Consulting, which was the former name of BAS, you don't even have a vesting of the equity from which a monetization could potentially have happened, which would only have happened in the event of a sale, as the plaintiff himself testified was the benefit of having that equity in the first place. So we have the plaintiff's own admission at trial as to what his intention and understanding was as to the granting of that conditional illiquid thing.
So let me say it more plainly. Your argument is, even if there was a breach, his equity wasn't vested, therefore you couldn't monetize it at the point of the breach.
Yes, among other arguments, but absolutely. There was one case, the Giordano case, that the trial court cited in a colloquy between and among counsel. I think it was in a sidebar. And by the way, the trial court also said in this sidebar, Your Honor, when trial counsel were arguing over this very issue, that is, should this case be tried to a jury? Isn't this a declaratory relief case? Isn't this a specific performance case? The court said to trial counsel for the plaintiff, and I'm quoting at the appendix page 467, you're adding the words buyout. You're adding the words buyout. So again, this is what happened kind of throughout the trial. We would submit this trial by ambush, this last minute attempt to recover something that had not been pleaded or discovered or litigated. And there's great prejudice as a result of that, Your Honor. We didn't come prepared to trial with a rebuttal expert as to any,
And this argument you're making, just so I can clarify where that falls under in terms of the issues presented to this court. Does this fall into you believe there was an error in admissibility of damages evidence? Is that where this argument falls in, or is it the verdict was against the great weight of the evidence?
so it falls under both, but in the first instance, it's our first issue. It's question one as
Okay.
set forth in our brief, where we posit that the trial court erred in allowing plaintiff to seek monetary damages on a breach of contract claim, which he did not seek in his operative complaint, and by which the trial court placed plaintiff in a better position than if the contract had been fully performed. So that's our issue one. We think it's de novo, but Your Honor, to the great weight question, and I'm happy to jump to that now because I think it's of equal, if potentially not greater importance, which is what was the evidence? Let's assuming just for the sake of argument, of course, that this case was properly tried to a jury, that monetary damages had been pleaded, discovered, and were teed up appropriately for trial, that the jury found a breach, which of course we don't think is consistent with the great weight of the evidence, but then the jury's award of $3 million. So there was no expert testimony as to the valuation of this business unit.
But there was testimony.
There was testimony. That's right, Your Honor. And it was testimony by the plaintiff himself, who the trial court had explicitly barred from offering any opinions, given the trial court's.
But it was simple math in the end, right?
It-
So the trial court allowed him. So it's not that the jury sold this out of whole cloth. There was testimony as to damages.
So what you said right at the end of that, the first part of that comment, Your Honor, is right. It's simple math in the end. So in the end, any expert is doing simple math. What's important are the inputs, the analysis, and the methodology in making a valuation of any business or any subunit within a business, which the trial court ruled was necessarily the subject of expert testimony and needed to be the subject of expert testimony. So Mr. High, the plaintiff, wasn't just doing simple math, Your Honor. In his testimony, his simple math, as was ultimately presented to the jury, was he testified to the total value of CIG Consulting, which he had no basis, qualification, or experience to do. He was undisclosed as an opinion witness. His opinions were undisclosed. He testified that his percentage at purportedly 49.95% to get to 2.813 million, such that, quote, his end of CIG is worth 2.8 million. There's nothing in the record from which any reasonable trier of fact could correctly conclude.
Well, I've got in my notes, plaintiff testified in October 2021, a third party valued CIG at 12.8 million, and that you did not object to this valuation. Let me finish. Is that correct or incorrect?
It is correct.
All right,
There was-
now let's go to the next
well,
step.
but-
Let me finish and then I'll give you every opportunity. See, the purpose of this is for me to learn, not for you to tell me what you think. So then what he does is he says, I'm taking 12.8 and multiplying it by 44%, correct? And then I come up with 5.632 million, but because he maintained he owned 95.95, that's where the number comes up. So what I'm saying is, again, these numbers were part of the record. You're trying to tell us they just appeared, but that's not the case. And furthermore, you didn't object to part of this testimony. So what's your rebuttal?
And I apologize for interrupting. Your Honor.
Don't worry about it.
So, yes, there were numbers discussed at trial. And yes, the first time that the plaintiff referenced this purported $12.8 million valuation, there was not an objection specifically to that question and answer. However, when the testimony went on by the plaintiff as to the relevance of that $12.8 million figure. And I would, as a next step, like to talk about where that came from. When the plaintiff went on to use that number as the first input to creating out of whole cloth a valuation of CIG as a whole and then BAS as an operating business unit, this is where it all, you can put down any numbers that you want, but there has to be an analysis and a methodology admissible under MRE 702 from which a jury rightly could determine what the actual valuation of this is. So again, it's not just a question of, well, yes, there were numbers at trial and plaintiff apparently had done some math in his head, undisclosed prior to trial, that he was going to use to support his purported non-expert opinion as to valuation when the trial court said that opinion expert testimony was needed for the same. It was completely inappropriate on the part of the court to let that in. And there was a long colloquy at the bar with counsel objecting to the use of that $12.8 million figure as towards not the fact that it was mentioned, but the fact that it was used for the purpose ultimately for which it was used at trial by the plaintiff. So there was absolutely an objection to the use, to the testimony of Mr. High to put all these numbers together to come up with this valuation. And
I don't disagree with that assertion that you did posit, or whoever tried the case did posit an objection, but didn't posit an objection to the 12.8. Is that true or not?
that is true.
Okay.
To that specific
And
question, yes.
Wasn't it at trial, wasn't there an opportunity to cross-examine and challenge whether that actually was true and how accurate that was in any event? All of that was developed and the jury could decide to believe it or not.
So there was that opportunity, and that opportunity was taken advantage of, Your Honor, by trial counsel for CIG. So there was questioning of Mr. High with regard to this. So where did the 12.8, and then there was also questioning of CIG's principal, Mr. Minkara, who explained what that document that was not admitted into evidence was and what it related to. So the 12.8 million that the plaintiff referred to at trial was his recollection of some third-party outside consultant, I think it was McKinsey, report that he had seen or had seen a portion of. We don't know when. They did not offer that document into evidence. He said, well, I saw this third-party report that put a valuation of CIG at $12.8 million. Okay. And Mr. Minkara, when he was given the opportunity to testify, testified that McKinsey or whoever the third-party consultant was, had been engaged by CIG to analyze the business as a whole, come up with a new compensation arrangement for the employees of the business. And based upon that and other projections and hypotheticals, CIG as a whole could be worth $12.8 million. It was entirely a hypothetical valuation. And perhaps most importantly, even if the valuation had any credibility whatsoever,
Isn't that
it wasn't a
sort
valid.
of the case of all business valuations?
Absolutely not. Well, sure.
Hypothetical?
Yeah, absolutely not. But hypothetical business valuations do not prove to a reasonable degree of certainty as to damages for a monetization of an illiquid interest in an operating unit of a closely held company make. I mean, no reasonable jury could rationally go from 12.8 million. Let's assume for the sake of argument that 12.8 million was the value of CIG on the date that, again, arguably CIG breached the contract, to Your Honor's earlier point.
Well, we have to, because that's what came in and you didn't object.
No. We did object to the plaintiff relying upon that figure in order to come up with the other figures that Your Honor mentioned.
I
in order
thought
to
you
arrive-
said earlier Here's what I read. Plaintiff testified that in October 2021, a third party valued CIG at 12.8 million. Defendant did not object to this testimony. You said that was true.
Right, but what I also tried to
What did I
explain,
miss?
so you didn't miss anything with regard to that question and answer, Your Honor. But the additional point that I made was that there was an objection made during trial
For him
and
doing additional math. He takes that
That's
number
right.
as the starting point
that's
and
right.
then does
Right.
division
I
and
understand.
multiplication and percentages
Right.
and then gets a number. And so you objected to that math, not that it's incorrect. The math is perhaps correct. But him doing math,
Him-
you object to.
Him doing math at all, given that the doing of the analysis, applying an accepted methodology in the valuation space is necessarily the subject of expert testimony. So yes,
But I
could
think the difficulty we're all having is the valuation was done by an expert.
it wasn't, Your Honor.
It's a third party person. He just took the evaluation and did relatively basic math.
Right, but relatively basic math to come up with a purported valuation of BAS. And it's
Of
so,
his share.
no, but Your Honor, he didn't have he didn't,
Here's where you and I have a disconnect. Let me just say this and then I'll let you go. You keep questioning this $12.8 million figure. And I keep coming back to the fact you didn't object. So you keep trying to cast aspersions that that's not a good figure. I don't think that's a credible argument. You follow what I'm saying? You let it come in, it's in. You didn't object. So you can't come to an appellate court and say, oh, no, that number was all wrong. What I'm hearing candidly from you, counsel, is great arguments for trial to object to that.
Your Honor, we have
A little
18,
late.
I respectfully would submit that we have 18 or so pages of trial transcript where trial counsel is objecting to the plaintiff's, not saying what the number is, but
So you think
using it to come
12.8
up.
is a fine valuation?
I don't at all, because there's no evidence that consulting report is not in the record. If there's a valuation, if it wasn't.
These are trial objections.
But they were made, Your Honor, they were made with regard to how that number was then used. I think that's crystal clear in the record. Just
Well,
what
obviously it's not, because I'm not getting what you're arguing at all.
well, we've got, like I said, almost 20 pages of sidebar in the record where it is being discussed with the court, CIG's objection to the use of that number. And let's.
I'll let you move on. I don't want to hold you up. Your time's winding down. I just think you and I I don't understand what you're arguing.
Well, fundamentally, Your Honor, what I'm arguing is that at the end of the day, expert witness testimony was necessary to establish the valuation of the particular business unit that was at issue here. The value of CIG was not at issue. The value of a business unit within the company was at issue.
What's your case law that says you need expert testimony to testify as to that? Why is it not enough to have a CFO and a CEO or two owners of a closely held business come in and testify and say, one say it's worth 2 million, one say it's worth 5 million?
Well,
And then the jury decides based on their testimony and their credibility.
Well,
What's the case law that says I need a business valuation expert to come in?
well, it's MRE 702, Your Honor, and the court's determination in carrying out its gatekeeping function as to what type of expert opinion testimony, what are the inputs to making a valuation of a company? The court correctly said, and this has not been cross appealed by the plaintiff, the kinds of things that are evaluated in connection with making a business evaluation of a company. And the court, I mean, I think it's also, They proffered an expert witness to do this a week or two before the trial was set to commence. So even the
I know you wanted
plaintiffs,
to save some time for rebuttal, so I don't know if you want to end on that note and then say 5 minutes, or if you want to take more time. But we're right about at the 5-minute mark if my timing's.
I'll save my remaining 5 minutes for
Okay.
rebuttal. Okay, thank you.
Yes.
Thank you.
Good afternoon. May it please the court, Lawrence Garcia, along with my colleague Eftiola Greco, on behalf of the plaintiff appellee, Yusuf Hai. I want to be very brief.
You know, every time a lawyer says that to me, they're anything but. I know you want to be,
Let me see if I
but the
can surprise
question
you.
is, will you be?
I think so, Judge.
I'm teasing you, obviously. Take as much time as you want, as my colleague Judge Young would say.
Thank you, Your Honor. I just wanted to set the context of this story. It starts in 2007. My client was employed 15 years with this company. In the entrepreneurial world, we call that buying in on the ground floor with sweat equity. He wanted to amass his retirement by building up this company. And in April of 22, he was fired after he dared to ask questions that we're still struggling with today. So I thank the court for the attention given to this very long saga, which is very important for my client and his family. I want to point out that I think the main of counsel's argument is about credibility. He's saying that the jury should have believed his witnesses and not mine. That's not proper to review in a court of appeal. I want to point out the irony regarding this sufficiency of evidence question. It was noted many times in the trial transcript that we only got some of the records from this company, despite very extensive discovery requests. Only some of the tax returns. And those tax returns that we did have were explored, and they provided a basis for all the conclusions that the jury made, even if everything else wasn't there.
Mr. Garcia, let me ask if I might, dealing with this valuation issue, clearly that was the case, correct? How much am I owed? What's the value of my, as you put it, sweat equity? Did the defendants put any expert or offer any expert testimony to counter this $12.8 million figure that we've been discussing?
I can tell you exactly what I think they put on against that, but it wasn't expert in the sense of a recognized registered expert who filed a report. They put on 2 controllers, they put on the CEO, they cross-examined my client and his thoughts about the matter, but they couldn't gainsay their own tax returns, nor the valuation that they commissioned through the company FP Transitions. Those things were kind of black and white. So I think they wanted to, Your Honor, but it was very difficult for them to do that, considering the record that they had created in filing documents with the IRS and in paying somebody a lot of money to say what their company was worth.
Let me ask you a different question, which kind of goes before that. We focused a lot on the valuation, but how do you respond to counsel's argument that, look, the contract provision at issue that was breached, it concerns the equity that your client would get, and that equity was not vested until the company was sold? How do you counter that and say his argument is he should just be granted a 25% stake in the company, however it currently sits, and it's just his potential lottery ticket he's sitting on, waiting to cash it in whenever it's sold? How do you answer that?
It's not the law in Michigan, Your Honor. The Giordano versus Markowitz case, which the trial court relied on and which we relied on at page 12 of our brief, says the opposite. It says that you only limit to equity relief when it's necessary to avoid injustice, but otherwise monetary damages are the correct form of remedy. And that's the law of this court, and that's the law of this state. And I think the trial court got it right when he recognized that. Furthermore, Mr. Minkara hired a lawyer named Aaron Sherman. And in his correspondence to Mr. Sherman testified at trial. He acknowledged that my client had vested or had acquired a certain equity interest in the company. And that was evidence submitted to the jury. Now, I know opposing counsel wishes the jury hadn't believed that, but that again is a credibility issue that's not properly before this court.
Understood. And in the, just to close the loop on this, there was some suggestion that, you know, seeking value or seeking money damages wasn't brought up until the eve of trial or something like that. Can you address that?
Yes,
line
it's
of
paragraph.
attack?
Yes, Your Honor. I beg your pardon. Paragraph 79 of the second amended complaint says plaintiff was financially harmed by defendant's breaches of contract, losing opportunities to seek better employment, losing the benefit of the money due to him when it was due, suffering emotional distress, and losing reputation in the business community. That is a clear expression of he was cheated out of money. That's what we sued for, and that's what we got. And I'd like to close by pointing out how the jury could have reached the $3 million number within the range of reasonable outcomes. If you take 12.8 and you cut it in half roughly, because CIG, separate from business advisory services, does about half the volume of business that business advisory services does. And then you cut that half number again, because my client only owned half of his half of the company. That's 1/4. And 25% times 12.8 million is roughly $3 million. That is a reasonable outcome for them to have reached using reason and the evidence submitted. Thank you very much.
I hang on a quick second. I have a question here for you.
For the record, I think you were brief before this question.
He was very brief, and I was, if I
No,
had a gold star
not
on
anymore.
me, I'd pin it right on. Can you tell me what a hurdle rate is, please?
Yes. Yes. Mr. Minkara did a lot on that, and we noted it for today's purposes, my colleague and I, the pages of the transcript that go to hurdle rates, Your Honor. And I'll just tell you,
Thank you.
volume 1 at page 173 through 175,
Okay.
again at 192, again at 204. And then it came up again in volume 2 at page 21. And finally, Your Honor, at volume 4 at page 20. Mr. Minkara and Mr. High explained that hurdle rates were deliverables, outcomes, KPIs, key performance indicators. He was supposed to hit certain numbers, and if he did, he would get a gold star. And
Right.
he would elevate himself in terms of his ownership of the business and his salary sometimes. The evidence was mixed, I admit. He had some negative performance reviews, but he had a lot of good ones, Your Honor. And the good ones said things like, you met your hurdle rates. That was, I think, our exhibit K. I apologize, I don't have that ready at hand. But there were instances where Mr. Minkara signed a performance evaluation that said you met your hurdle rates. It's a great question what they are. It's a little nebulous, but I think the evidence clearly established whatever they are, my client satisfied them, at least on some of the years that he was working for those 15 years.
And I guess specifically for our purposes, certainly there was sufficient evidence within the record upon which the jury could rely. That would be your closing statement on that, I suspect.
Absolutely, Judge. And again, the fact that there was countervailing evidence on the other side is interesting. That's what makes a trial a trial. But the jury gets to call which is the more credible evidence, and they sided with me.
Because you're brief. Thank you very much.
Thank you, Your Honor.
Before you get into rebuttal, you don't rebut what how he just explained hurdle rates to me, do you?
I don't.
Okay, thanks.
Yeah. But I would like to address counsel's other comments. So I think the court knows, but I'll say it anyway. This is not just a question about witness credibility. There are legal questions that are reviewable on a de novo basis in addition to great weight of evidence questions. And, numbers and doing math is not a question of credibility. Those are just numbers. And I don't want to revisit too much this valuation testimony, but one of your honors asked, where is something more than just math? And I wanted just to point you to the trial court's ruling when he barred the plaintiff from offering opinion testimony. The court, citing learned authorities, identified the various factors to be taken into account in making a competent business valuation. Quote, in the end, the plaintiff failed to show that this line of testimony could be presented by a layperson, citing MRE 701. Court went on, generally, the valuation process analyzes all aspects of the business, including the company's management, capital structure, future earnings, and market value of its assets. That was never done, never admitted, not even presented to the jury for consideration with respect to BAS. With regard to counsel's comment that they asked for a bunch of records for us and did not get them, that was a matter that should have been resolved by them in the trial court. What happened was they issued requests for documents and information, literally requested every business record of the company for all time. The court sustained our objections to the breadth of those requests, and they never moved to compel them. With regard to tax returns that would have been, I think counsel said, of public record, a tax return does not give you a business valuation. And that's what was missing here. So the court's question about whether CIG offered expert testimony, it's an issue that they raised in the response brief, saying that the onus was on CIG to present an expert to explain why an expert was needed to make a competent valuation. But that was not our burden. That is a function of the court's gatekeeping role under 702. And the court made a determination that expert testimony was required, and they didn't appeal it. So that issue is not properly before the court. With regard to the Giordano case, which both the plaintiff and the trial court relied upon to allow a monetization of the interest, in contrast to the 2007 letter agreement at issue here, which, as I said, refers to the equity vesting in the event of a sale. In Giordano, there had already been a vesting and there had already been a sale. And so the award of monetary damages wouldn't visit an injustice, whereas here it would, because that's not what the parties bargained for. So the case is distinguishable. With respect to Attorney Sherbin's testimony, this, and we strongly believe, of course, in all of our 7 arguments, but this testimony went to not the valuation of the business, but whether or not there was an oral amendment to the 2007 agreement. The plaintiff
About a minute.
testified he retained Attorney Sherbin to document the parties' alleged oral amendment to the 2007 agreement. Attorney Sherbin testified that he never spoke with CIG's principal. He only spoke with the plaintiff, and a document was prepared but never signed, which proves the opposite of there having been an amendment, because there was one presented, but it wasn't agreed upon. And with regard to paragraph 79 of the second amended complaint, all of those allegations relate to bonuses, damages, other damages, claims, loss of reputation, all of which the plaintiff lost before this case went to trial. It's paragraph 77, as I referenced, that specifically references the equity interest. And again, that's the one that the parties litigated for 2 years. And my client ended up being ambushed at trial by the presentation of math as purported competent valuation testimony when it cannot and does not pass muster under any applicable standard. And we thank you.
Thank you, Mr. Garber. How was your trip, by the way?
It's great.
You came from Chicago?
I did.
Did you fly or
I
drive?
did.
Yeah.
I flew.
You know, if you go up along the west coast of Michigan, don't tell anybody you're from Chicago. They claim that you bought up all the pretty places. but that's a great town, Chicago. Are you from there originally?
I am, Your Honor.
Born and raised, huh?
Born and raised, lifelong.
Yeah, it's a great place to live.
Thank you.
Do you live in town or do
I
you
do.
live
In town.
Awesome.
Yeah.
Well, enjoy.
Thank you again.
Thank you. It was an excellent argument. Appreciate your time.
Thank you. This case will be submitted. Now calling item number 26. It's docket number 375123.
What about 25?
25.
Oh, I'm 26 minus 1. I'm so in the mood for math. 26 minus 1 is 25. We are calling case 25. 374757. That's Auto Financial Group LLC versus City of Taylor. Appellant is here remotely. So, appellant is here remotely. So let's take a beat
Oh,
and make
that's,
sure.
she's the applicant. Okay.
Yeah.
Judges, it's Mike in the clerk's office. Mr. Ganem is not in the gallery. I did reach out to him during breaks. I noticed he was not there, and it was his intention, if he couldn't make it, that he would rely on his brief and waive.
Yes.
That's
Okay.
not the voice of God. That's Mike Wolcott, who's our.
Thank you, Mike, and thank you for following up in advance of this. We really appreciate that. So understanding that, I know you have someone with you. I don't know if you wanted them to sit at council table.
I guess I'll just put an appearance on the record.
Sure.
Good afternoon, Your Honors. My name is Amanda Waskey. I'm here on behalf of the City of Taylor. I do have someone with me this afternoon. Her name is Cameron Spanga. She is our undergraduate intern in our office this summer. She is a student at the University of Michigan pursuing a degree in organizational studies. And she has expressed an interest in attending law school. And so I thank you for the opportunity to be here in person today so she can see a real courtroom with real judges and real lawyers arguing real cases. And she gets a reprieve from line by line deposition summaries. So
Go into dentistry. You work 3 days a week. You make a ton more money.
And you get to sell your practice.
And you get to sell your practice when it's done. And
But make sure you get a valuation expense
That's
for
right.
and their testimony admitted.
and get your experts. Yeah. If counsel for appellant is not here,
The law's
I am-
pretty clear here.
the
right?
law is pretty clear here. There were a few points I would be happy to highlight in rebuttal to any argument he would make, but our briefing is pretty comprehensive. I think the law is clear.
Can I, just out of curiosity, was there ever a discussion on why the law is what it is relative to the used car? Did you just not want used car lots in Taylor or?
You know, I did not represent the city of Taylor in 2011 when the ordinance was changed.
You weren't even born yet, right?
Well, I was born. I was born and I was a high school graduate. I was also attending the University of Michigan during that time. I will say this, you know, a city council is entitled to change their ordinances after you have, for example, a critical mass of a certain type of use established in the community.
Sure.
Or you have a new group of people with new political interests who come in and sit on a city council or a board of commissioners, you know, depending on the size of the city. And so as long as the council follows those proper procedures, they're entitled to make those changes. And that's what happened here in 2011. They made a determination that there's no more public need for standalone used cars dealerships and that there's sufficient availability of that use already in the community and specifically along Telegraph Road. And so they changed the ordinance, and it's not unusual and it's certainly not illegal to do so. And to the extent that appellant doesn't like the ordinance, which it's very clear that they don't, and it's very clear that they find that its application to them is fundamentally unfair, but that's really gratuitous in the context of an appeal from a ZBA.
And it was in place when they bought the property.
Correct. And it's not a situation where there's been a continuous use of this property as a standalone used car dealership. That business ceased in 2017, as appellant admits readily. So to the extent that there's not any other questions. I'm
You ever
happy-
have to work with that David Greco guy?
No.
No, you don't?
I don't.
Oh, okay. He does work for the city of Taylor, so
Yep. No, I work with Ed Plato mostly.
gotcha. Okay.
Mhm. So if there's no other questions, I'm happy to rest on my brief.
Thank you.
No questions, Judge.
This case will be submitted. Thank you very much.
Thank you.
And congratulations to you on your future in dentistry.
Yes, it's the way to go. Trust me, 3
Oh.
days a week. 3 days a week. Think about that. Make almost $1 million a year. Whoa, that's living.
And go blue. Yes. Now calling case number 26. For real, I am calling it. 375-123. This is Yusuf Gorgeous versus Auto Club Insurance Association. And it looks like only appellant or no, wait, defendant appellant are both parties
Yep.
endorsed? Okay.
Yep.
Just not plaintiff appellee. Okay. Got it. Okay.
Good afternoon, Your Honors. Josephine Di Lorenzo on behalf of Defendants Auto Club and Members Select.
Counsel, when you get back to the office, you tell Mary Masseron she should have come today.
She's trying to retire.
I know, but she should have come, or tell her not to put her name on, because I would have feigned an illness if I knew that she wasn't coming and sat at home today, but I was gonna come just because Mary was coming. So you tell her how deeply disappointed I am.
I will.
Now strategically just don't include her on anything so he won't be present.
That's a good strategy.
If you could, obviously, if you don't mind me sort of directing you, at least initially, for me, what stands out on, what the issue that sort of jumps out to me, and I think it is really the only issue, is this concept of independent contractor versus employee. Tell me why, in your judgment, and I forget the fella's name, it's right here. Mr. Georges is an employee and not a independent contractor, as his employer says.
Well, I mean, we went through all the factors in the brief. I could go through all of them. I would say the highlights are that he worked for that company 6 days a week. He didn't have time to work anywhere else. So all of his employment income came from transport systems. He drove their truck and their trailer. It was their GPS system. It had a dash cam that they owned. They required the specific application on his phone. So I would say those are the highlights.
So essentially you're arguing he's a captive provider, right? Essentially.
If that's the term, I'm not familiar with that, but I will go with that. Yes.
Okay.
He's not working for anyone else.
It's used in, I don't know, more wage and hour cases and things like that, but along that line of thinking, what case do you think is most analogous or controlling that follows that line of reasoning?
Well, we did quote from the Duckworth case
Okay.
a lot, because that was the same situation.
Now let's talk about Duckworth.
I think it's a questionably authored or participated in that panel.
There's another case too, right? That
Your
deals-
case,
Right.
Adenauer.
That goes the other way.
That was the case I was thinking of. That was
Correct.
questionable.
So tell me why I should follow Duckworth as opposed to, as you put it, the A case.
Well, that was sort of for the other proposition of where even if you find that he's an independent contractor, should he still be covered by the insurer of the truck? And I think that Duckworth and Adenauer are opposite on that. Duckworth came later and it was trying to clarify the law, and that's why it put those that two-part test. And I guess I would say, I mean, I know the opposite position is, well, since our plaintiff didn't actually own the truck, so he's not an owner, so he doesn't fall under the statute, as a self-employed person. But the problem, I guess, in Duckworth is that there was one appeal and this court sent it back and it gave this two-part test, knowing that he didn't own the truck. And then they didn't reach the issue. So we were sort of wondering if you were going to reach that issue in our case, because on remand, the court said, well, he is an independent contractor, but he's not working for himself because he doesn't have his own business entity. So this court then sort of didn't address the issue that's here in our case, and it just said they didn't agree on the independent contractor issue, and they said we don't get to that second part. So it makes it sound like there is a second part, and where you could reach that in this case if for some reason you do think that he's an independent contractor. But I do think that all the points go in our favor. If you had specific questions on
No, thank you.
You have anything?
No.
You have
Thank
plenty of time for rebuttal. Thank you very
Okay,
much.
thank you.
Unless you wanted to add something else, because I know we cut you off.
No. I mean, I was just gonna talk about, I mean, I just summed up my, my view of the factors for independent contractor. And then I know there's there seems to be a disconnect between Duckworth and Adalnik. So we were just hoping that you would resolve that in our favor in this case. Okay.
Thank you.
Good afternoon, Your Honors. David Shiner on behalf of Appali Carolina
afternoon.
Casualty. Pardon?
I said good
Oh,
afternoon.
Thank you. I
Sorry.
thought the questions were starting already.
No, I give you at least 5 seconds.
Yes, thank you.
I think that's generous.
So Judge Borello, you did kind of pinpoint the issue here as far as whether Mr. Gorgas was an independent contractor or employee of transport systems. And we've both discussed very thoroughly in our briefs the economic realities test, and the testimony is from Mr. Gorgas himself is very, very clear. And he described a arrangement by which he had complete control over whether he accepted loads from them. He was offered loads on these per load basis, and he said, I make my own schedule.
What does the testimony show or say if he would have rejected 3 loads a week and said, all of a sudden decided, you know what, my kid's home sick for these 3 weeks or month, I'm only going to work 2 days a week? What would happen then? What's the testimony say about that?
Well, he made very clear that I had I had all the autonomy in the world to reject that and to reject the loads that were offered.
Didn't he say, counsel, though, if I would have rejected loads, they would have stopped calling?
Well, he said if they were busy, they would put pressure on me, but that's just, I mean, in the furtherance of business to say, we have this independent contractor, we need you to transport loads. But there wasn't any specific testimony about what would happen, or I guess what the consequences were. But in other parts of his testimony, he made very clear, I make my own schedule. He responded yes to that question. I am free to reject any loads that I want. He is essentially working when he wants, whether he wants, when he wants, and under the terms that he wants. So that is very determinative here as far as, I mean, that's not characteristic of an employer-employee relationship.
But he can do that as long as he drives a truck owned by your client, hauling the loads for your client, using the app for your client, and going to the destinations for your client and complying with their general rules and procedures.
Well, he testified there were no rules and
Okay,
procedures
but everything else he
that
said was
follow. Well, as far as the app that was provided, it was an app that is through the Department of Transportation that just tracks his activities. It's not necessarily it's not a transport systems app, and it's not required by them. It's part of how truck drivers are tracked
But does
to
the
comply.
Department of Transportation require it?
Pardon?
Do they require it? The Department of Transportation, is it mandated by the federal government or the state?
Well,
Or is it mandated by your client?
Well, it's mandated by them as far as you have to use an app to track and to make sure that you're in compliance with a.
Correct. And they said you have to use this app.
I'm not sure that he said that very specifically. He just said, we use an app as truck drivers to ensure our compliance with the regulations or the limitations under which they can drive. I mean, they're obviously limited to a number of hours that they can drive every, or chunks of time that they can drive and take a break. But it's really in compliance with, or to ensure compliance with those Department of Transportation regulations. But going to, again, as far as how, I mean, he's offered these loads. They say, do you want this? And he said, I am free to say no whenever I want. I can take a load when I want. I can, and he very regularly chose to take them.
Help me understand in terms of compensation. My understanding is that it wasn't based on mileage, but it was based on destination.
It was the way he described it was per load, and how it's calculated. I'm not really sure as far as the amount of money, but as far as
how does you're not sure how your client pays these independent contractors?
Well, and the way he described it was per load.
Okay, and my understanding is that per load, but it wasn't based on mileage, it was based on where the load was, it was based on where the load was going.
But that would, that would include the mileage if
Okay,
he's going to
so-
Texas versus California.
So he gets paid more to go to Texas versus going to Ohio,
Right.
right? Why is that not just another way of saying you're getting paid hourly or by the mile? We pay $1,000 for a load to Texas, we pay $500 for a load to Ohio.
Well, I mean, in any independent contractor situation, there's a metric by which they're going to, I mean, it's per load in the sense that, I mean, you're getting paid for what you're doing, but I don't see that transitions it into, you know, essentially being a wage. I mean, he's working when he wants. And the other important thing is here that he had his own, I mean, he was the proprietor of this separate Gorgas trucking company. It's what he claimed on his taxes as far as, you know, he filed taxes as a proprietor of that company. He filed taxes as a self-employed person through that company. So there's not really a question that he was self-employed by this Gorgas trucking company.
Would you agree, going back to I mean, what you're saying is he's paid per load. What's the difference between under the FLSA where you're permitted to pay a piece rate? Why is that not the same then? I get paid $5 for every one of these pieces that I put together on the manufacturing line. How's that difference? I get paid $500 per load I take. So if he can speed to Ohio and go back and forth 3 times in a day, he can get paid $500. I mean, that's a recognized rate of pay. That doesn't, just because you pay him by load doesn't exempt you from being an employee.
Well, I think it's the overall picture of how he chooses whether to work or not. And I mean, you know, in the event that he is offered this load and in the event that he chooses to accept it, which he freely can, I mean, he acknowledged, I am free to say whether I want this load or not. When he does that,
Who inspects the load before leaving?
it leaves from, he said that the loads are, I mean, so he drives.
He drives the trailer. Or he
drives the tractor.
Drives the tractor, backs up. Who's the one making sure that the load meets all the safety regulations? Who's going back and making sure the straps are all wrapped, make sure the tires are inflated, that it's all hooked up properly?
There might be different people involved in that. What he said was that the tractor, I mean, the trailer is just connected to his tractor and he's off. So
he takes no responsibility for any of that then?
I mean, I guess this wasn't explored in his deposition as far as, you know, the steps that he goes through from arriving at the yard to, you know, when he leaves. But again, as far as him having the complete autonomy, as far as when he works, whether he works or not, and, you know, being free to say no, that's just not characteristic of an employee-employer relationship. And I mean, again, he was, the way he described that he was paid was that Transport Systems would write a check to this company of which he was a proprietor of, that was Gorgas Trucking, and that's, you know, he got paid by them. He claimed.
But I mean, I get what it says on paper, but you know as well as I do, the courts and the law in all areas of law look beyond labels, look beyond how you pay them as a 1099. I mean, those factors are almost meaningless. That's why we look at the totality of the circumstances, because just paying someone by 1099 doesn't tell you anything. Just because you set up an LLC that costs you, you know, a $35 annual fee with the state of Michigan doesn't mean you're not an employee. So I'd say those factors, I wouldn't lead or rely too heavily on those factors.
Okay. And again, when you're claiming a certain status for purposes of your taxes, though, there's, I mean, that's worth a little bit more. I mean, as far as the federal government's concerned, he's self-employed by this separate company. As far as he's concerned, that's what he's claiming for purposes of his taxes. So I understand what you're saying as far as what's on paper, but it's more than just, you know, writing something on paper. He's taking a legal status when he's filing his taxes that way, for example. But to get into the factors also, I mean, there was no testimony about, I mean, once he's off, once he leaves that, well, even before he leaves the yard, There's no control that they exert over him. They don't monitor him. They don't
call and check on his status?
No, what he said was, I just have to take, I have to input that I'm taking a break, but I have to do that because of with the app. And
The app that your client requires him to have on his
it's
phone.
I don't think he testified that it was required by my client. He just,
Okay.
and transport system is not my client, but by transport system, the way he described it was, this is an app that is required for any truck driver to just monitor my activity to make sure I'm within the regulations. But when they didn't check up on him, he said he can take whatever route he wants. He can do it at his, at his own pace. And so going beyond the fact that he can work whenever he wants, whether he wants, when he did.
So he goes to Ohio via California. That's not an issue to your client hauling their cargo to California and back. That's not an issue for transport.
No, I mean, well, it's an issue for both of them because it's probably, it's a waste of his time and,
But what's it matter to him? He's got an opportunity for profit or loss. That's the essence of an independent contractor and economic realities.
yeah, I think we agree that it wouldn't be in either one of their interests for him to do that. But
if he was independent, he could choose to do that if he wanted.
and
Not have any repercussions.
well,
Yeah.
well, he did say that he was never disciplined. He was never disciplined for anything. But when he was asked about the GPS that was in the truck, he was specifically asked, could you change the route if you wanted? And he said, yeah. The only thing stopping me was if there was a route that didn't allow trucks, I couldn't take that route, obviously, but he said he could go in and change it. So if he wanted to take a little detour to Los Angeles and,
But your client preloaded the GPS for him.
well, it was part of the equipment of the truck. But as far
That transport owned. So it was their GPS system.
Right.
He would get in the seat and the destination would be put in for him.
he didn't testify that specifically either, but as what he did say was, because this question was asked, if you wanted to change the route, the actual, the roads that you took, you were free to do that. And another thing that he did testify to was he split operating costs as well. I mean, that was paid for. I mean, it was 50-50 as far as highway taxes. He explained that there was an easy pass or something to take care of the tolls. He paid for half of the gas. So he's operating as an employee of this Gorgas Trucking that he was a proprietor of. And this is a joint operation between two entities, essentially, one of which he's an employee, his own trucking company, and he's driving the transport systems truck. So as
Hired of his own trucking company without a truck.
pardon,
He's a proprietor of a trucking company without a tractor.
Truck.
Tractor.
yeah, no,
Tractor,
yes,
Yeah.
well, I mean,
If it'll fit in the cab, I'll transport.
he is the yeah, I mean, he is I guess when you think of a situation like this, there's, two pieces of what's needed, a truck and someone to drive it. He is one piece and
He's the
transport.
driver.
Yeah, transport system has
He
the
has a
other.
driver company.
Well,
Not a
sure.
trucking company.
But going to the statutory argument, unless there's any additional questions, as far as the economic realities test and the factors to consider.
No, I fully understand your argument.
Thank you. And just as far as some of the case law that was discussed in the statute itself, so 500-3114-3, it has certain elements that have to be met here. One, right, I mean, it contemplates the employee who is the injured person, but in order for there to be coverage under 31143, they need to be driving a vehicle that was owned or registered by their employer. Here we have a disconnect between the two. He can be considered a employee of himself or self-employed, as some of the cases discuss and analyze that issue. But again, in order to fall within coverage under 31143, you need to be driving a vehicle that is owned or registered by your employer. And that is what the appellant is reading out of that statute. The argument here has been that as long as you determine them to be a employee of somebody and they're in the course and scope of that employment, they get coverage under 31143. That completely ignores the statutory language that requires that they need to be operating a vehicle that is owned or registered by their employer.
No further questions. It was very well brief. Thank you.
Thank you, Your Honor.
Yeah, and you have some time for rebuttal if you have anything.
I don't think I have anything to add. So is there anything you wanted me to follow up on or any other questions
Let me ask my questions.
other than to
Nope.
deliver a message to Mary?
No one wait.
Yeah, you're looking, if you look around, you'll see you're the end, right? You're like the last people after at the dinner service. So all set. Thank you.
Thank you very much. This case will be submitted. Now calling item number 27, docket 374352, Darnell Jones versus Genesee Genesee Circuit Court Judge. Neither party is endorsed for argument. This case will be submitted on the briefs. Now calling item number 28, docket 374517, Inri Saucier minors. Nobody's endorsed for argument. This case will be submitted on the briefs. Now calling item 29, case number 377790, Inri Ristic, and no one's endorsed for oral argument. This case will be submitted on the pleadings. Thank you all very much. That concludes panel 2026 session.